Were you aware that because of my hand surgery, it was a disability?
Because of your hand surgery that you had disability?
Yes, so because of my hand surgery and the prescribed medications that I was prescribed from a physician, my hand was a disability that I was taking medication for. My,
Okay, if you say so.
okay, so had you ever heard me ask you that I don't have sufficient rides to get back and forth throughout the week?
Yes,
Um, does your facility accommodate people that have disabilities to get back and forth?
we don't offer rides if that's what you're asking.
Okay, I mean, so being a supervisor, um, shouldn't your facility accommodate people to get to the facility?
I don't think that's a relevant question. She's testified that they don't offer rides.
Okay. Um, back to Mr. Bivens, coming back from Arizona, and you're his supervisor. Um, do you guys provide people that get referred to your facility with policies and procedures?
No,
Um, are you required to?
no.
Because through the legislation, you're required to do this. If people,
And with all due respect, sir, you can ask her a question. That's argumentative. You're testifying. So, ask another question, sir, if you have one.
okay. Mr. Bivens, he told me that I had to go ahead and fill out the paperwork again when I got back from Arizona. And so being that I asked for the policies and procedures, you guys, is it fair to say that you guys make up things as you go along?
No.
What you're about to witness is not just a routine bond revocation hearing, it's a masterclass in how not to behave when you're already skating on thin ice with the court. This defendant is here facing serious consequences after turning what should have been a misdemeanor DUI into a felony by picking up a third offense. And instead of showing accountability, humility, or even basic preparation, he walks into court armed with excuses, entitlement, and a wildly misplaced sense of confidence. From the jump, even his own lawyer signals there's a problem, telling the judge there's a reason he can't continue representation. That alone should tell you where this is headed. The live stream gets cut, tensions rise behind the scenes, and when the camera finally comes back on, we're dropped straight into the middle of a chaotic cross-examination where the defendant believes he's smarter than the system supervising him. He's going to argue that hand surgery excuses drug testing, that supervision officers should provide transportation, and that court-ordered conditions are somehow optional if they're inconvenient. But here's the problem, this judge isn't buying any of it. What starts as an attempt to poke holes in procedure quickly turns into the defendant exposing his own non-compliance, misunderstanding of the law, and refusal to take responsibility. Stick around because every minute of this hearing digs the hole deeper, and the consequences are coming fast.
Okay. Are you aware that on all my paperwork that I have, almost every one of them are marked that I was working full-time?
The case managers mark, they ask you that question and they mark what you tell them.
No, that's untrue.
Respectfully, sir, don't argue with the witness. You
Okay.
can ask questions.
Okay. So are you aware that on my paperwork, it was saying I was working full-time?
On some of those papers, sure.
Okay. Just for, I guess the record, I was not working full.
Sir, with all due respect, you're asking this witness questions. You're not testifying. If you want to testify, Mr. Ortega, you'll have an opportunity to do that. And when that happens, Ms. Pearson can ask you questions. So you can't testify now. This is not your opportunity to testify or present evidence. You're asking this witness questions.
Okay. And so I'll be able to testify today.
If you want to testify, yes, sir.
I will like to do that.
So do you have any other questions you want to ask, Ms. Tuttle?
On a level three, supervision, you never said anything about having a person take a mobile breath and being on a mobile breath system. Is that not a part? Because I asked you what it consists of. You never mentioned the mobile breath.
You asked me about intensive supervision, so I was explaining to you what intensive supervision was.
Well, according to RMS,
Sir, respectfully, she's answered your question. If you want to ask her another question, you can do that, but don't argue with her.
the level three intense supervision, does it require people to have a mobile breath unit given to them and take wherever they go with it?
So the level 3 portion of your bond is what requires you to have the mobile breath unit. The supervision level, your intensive supervision, you could be a level 3. If the court ordered a level 3 supervision, they could have you on a different supervision level. You specifically were ordered to level 3 DUI with intensive supervision. The level 3 is what requires the urinalysis testing and the mobile breath testing.
Okay, I understand. No further questions.
Right here, the defendant launches into what becomes a recurring theme throughout this hearing, attempting to rebrand personal inconvenience as legal exemption. Notice how he frames his hand surgery and prescribed medication as a disability, not to request reasonable accommodation through the court, but to retroactively justify ignoring bond conditions. That distinction matters. Courts absolutely recognize legitimate medical limitations, but they also require documentation, motions, and approval. None of that is happening here. Instead, he's asking a supervision officer to validate his personal interpretation of disability law, hoping it will override a judge's order. And when the witness responds neutrally, he presses harder, shifting the burden onto the facility, implying they should somehow accommodate him without a court directive. This is where his strategy starts to unravel. The court isn't hearing evidence of inability, it's hearing evidence of refusal. Every answer he doesn't like is treated as unfairness instead of procedure. And more importantly, this line of questioning isn't helping him. It's establishing a clear record that he never sought proper relief through the court before choosing noncompliance. That's a dangerous position to be in during a bond revocation hearing.
Did you have any questions, Ms. Pearson, that you wanted to ask?
Just a couple. Ms. Tuttle, has Mr. Ortega ever been fully compliant with his bond conditions?
With every portion of it? No.
Of the medications that he provided, do you know if you have other clients with those medications?
Probably so.
Does it make it so they can't report to RMS?
No,
Does it make it so they can't provide UAs?
no,
Does it make it so they can't do the mobile breath tests?
no.
Do you have clients that use MedRide?
Some do.
Walk,
Yes,
ride a bike?
correct.
I have no further questions.
Did you have any additional questions based on Ms. Pearson's questions, Mr. Ortega?
Yes, I did, Your Honor. Mrs. Toll, were you aware that I was riding my bike to get back and forth to RMS?
Sometimes, yes.
Okay. Knowing that I was on prescribed medication and speaking with some of your supervisors at RMS, they told me that if I didn't show up for my scheduled meeting, they were going to send an affidavit to the judge for my arrest. Is that correct?
They probably informed you that they would send an affidavit for noncompliance because you weren't complying with your bond conditions.
Right. But they also said that they would send an affidavit to the judge for my arrest.
I can't speak on what they said.
Okay. So knowing that I was on prescribed medication and you knew that I was taking my bicycle to get there, I mean, didn't you think that possibly was an issue at any point?
How you get to the office has nothing to do with us. If you're court ordered to be in the office once a week, then if you don't come once a week, then we have to inform the court.
Right.
That's our job.
Okay. Has there ever been anybody that had a condition that you were aware of that it was hard for them to get to RMS?
Yes.
Okay. And did you accommodate anything for them to be able to get there?
We can't make accommodations. What we would say is you can file a motion with the court and request phone meetings, and then we can do the meetings over the phone. But we can't give you rides or say you don't need to come in because you have this or that.
On some of RMS's paperwork, it says that you guys are counselors, correct?
No.
I have proof of that. I just don't have it with me today, Your Honor. Being said that counselors are,
You know, she's indicated, sir, that they're not counselors.
Oh.
So any question about counselors or what counselors might be required to do or not do is not relevant.
okay. I do have a copy here, Your Honor, of.
Sir, and again, what you're doing is asking this witness questions.
Okay,
Do you have any other questions you want to ask her?
yes. Do you remember when I put in the non-consent form on the 25th?
Objection outside the scope of cross.
You know, I'd allowed some testimony regarding this earlier, so I'll go ahead and allow it.
Can you ask your question again?
Yes. Are you aware of the form that I gave to you, actually RMS on the 25th of February saying that I did not consent to them taking my urine, doing any more testing on my urine?
I said I do remember you provide, I don't know what date you provided it, but I do remember that form, yes.
Your Honor, I do have a copy of that. I'd like
And
to.
again, sir, this is not your opportunity to present evidence to the court. You're asking this witness questions.
Okay, no more questions, Your Honor.
Ms. Tuttle, can Ms. Tuttle be released? Ms. Pearson?
Yes.
Mr. Ortega, can Ms. Tuttle be released? Ms. Tuttle, I appreciate your time with us. Just don't discuss your testimony with anybody. Yeah, if you'd like, yeah. I'm going to let Ms. Tuttle, if she wants to stay in the courtroom, she can.
Your Honor,
But she wouldn't be recalled by either side.
may I use the restroom?
Sure, we'll take a short recess. And then let me just ask Mr. Ortega, and I'll let you take a recess. Are you intending to call any other witnesses?
Well, I would like to call more witnesses on my behalf, but I wasn't prepared for this.
Well, there's two witnesses that are here, so while you're using the restroom break, you can let me know, think about whether or not you want to call any other witnesses,
I'd like
and
to
then,
call.
okay,
Thank you.
so we'll be in recess for a few minutes.
This is the moment where entitlement fully takes center stage. The defendant isn't asking whether transportation assistance exists. He's questioning why it wasn't offered to him, as if compliance agencies are responsible for managing his logistics. That's not how this system works. Pretrial supervision exists to monitor compliance, not to make participation convenient. The judge correctly shuts this down by steering him away from argumentative questioning, because what he's really doing is testifying through questions. He's framing himself as a victim of bureaucracy while ignoring the fact that thousands of defendants manage these same conditions every week without issue. What's especially telling is that instead of filing a motion requesting modification or communicating proactively, he waited until court to complain, after violations already occurred. Judges see this pattern constantly and it rarely ends well. This exchange quietly confirms something critical. The defendant didn't misunderstand the rules, he disagreed with them and decided they shouldn't apply to him.
Why don't you make an offer of proof to me, Mr. Ortega, why you want to call Miss Miller?
Your Honor, on several occasions, Mrs. Miller was my case manager, and there's paperwork that I have, and here's one of them that I did happen to have with me. They're falsified, and so I like to call her and cross-examine on it to ask her questions.
And the document that you have that you want to ask her questions about, what is that document?
It is a RMS document right here with her signature on the bottom.
Okay. Can you show that to Miss Pearson?
Yes.
And can you approach Mr. Ortega so the court can look at the document?
And that's how they copied it for me, Your Honor, just like that.
And is this the only thing that you want to ask Miss Miller questions about?
No, I'd like to ask her, as far as, what her, level 3 is, intense level 3. I'd like to see what she
Well-
felt up.
And I'm not going to allow that because Ms. Tuttle's testified about that. So respectfully, sir, what part of this document, and this appears to be a document, did you write on this document?
I did write on that document. I wasn't planning on using it for evidence, but
Okay.
since you said that I could, well, since I called her to the witness stand and her name's on it, I would like to use it.
What specifically are you going to ask her about? What do you believe is false on this document?
It says that I was working full-time on there and I was not working part-time, actually. It says part-time. She marked the box part-time. I was not working part-time.
Okay. So that's the only thing that you're saying is inaccurate on the form.
Well,
Is that correct?
I believe that there is other things that are,
Why don't you tell me what information on this form, Mr. Ortega, you're alleging is incorrect or false? So that's the one thing, the employment. What else?
well, after I put the non-consent of them testing my urine, they continued to test my urine.
Right. And so that's respectfully, sir, just because you say don't give your consent doesn't invalidate any court order that you comply with the conditions of your bond. So that honestly is irrelevant because unless the court modifies that, you don't have the ability to unilaterally say, you can't test my urine. You don't have the right to do that. So that's irrelevant.
Okay, well, I'd like to cross-examine her on, how she assesses different people with different disabilities.
And I don't know that that's necessarily relevant either, Mr. Ortega. Can you tell me why you think that's relevant?
Because I wrecked my mountain bike going to their facility and they knew that's the only way I was able to get there on occasions.
Okay.
And so I went to the ER and let them know that I went to the ER to try to get there to accommodate their facility because of it's a court order.
And so I don't understand the purpose of asking her questions about that.
Well,
That you wrecked your mountain bike going to the office and tell me how you think that impacts them. I'm not understanding you.
yeah, so it impacted me for the court order to go through them and I ended up in the ER and that's irrelevant.
Here's where courtroom control becomes unmistakable. The judge repeatedly reminds the defendant that this is not his opportunity to testify, argue, or editorialize, and yet he keeps doing exactly that. This isn't just a procedural correction, it's a warning. When a judge has to explain the same boundary multiple times, it signals growing impatience. The defendant's insistence on correcting paperwork, disputing internal classifications, and narrating his own version of events is strategically disastrous. None of that belongs in cross-examination. Worse, every interruption reinforces the perception that he doesn't respect the process. Judges expect self-represented defendants to struggle, but they also expect effort and restraint. What they don't tolerate is someone hijacking the courtroom to litigate grievances instead of facts. At this stage, the record is no longer about whether the system failed him. It's about whether he's capable of following basic court instructions at all.
It is irrelevant. I mean, if you think it's important because that maybe impacted your ability to comply with a particular condition on a particular date,
Okay.
That might be relevant. But the fact that you were riding your bike and you got in a wreck and you had to go to the ER in and of itself is not relevant.
Well, the only thing I can say is, I guess that's the only thing that I wanted to question her on because she's done it on different occasions as far as mark the box that is untrue. And there's some of the paperwork that I have saying that I was working full time. That one particularly says that I'm working part time, but there is ones that she particularly, and I know this for a fact, And I
But
have,
that's the only thing on the form. Did you ever represent to them, Mr. Ortega, that you were working part-time?
I did.
Okay,
At some point I did, after my hand started to heal.
okay. So then the information in July of this year, were you working or had you been working part-time prior to that?
I don't know.
You don't know when you were working?
Well, the thing is, Your Honor, I was on medication from the beginning. I have the transcript saying,
Okay.
Your Honor, I can't make my own decisions, I don't think,
Okay.
because I was on medication.
So the only concern, I just want to make sure, Mr. Ortega, the only concern that you have with this form that you believe is inaccurate is that the box was checked that you were working part-time and potentially on another form checked that you're working full-time. Is that right?
Well, honestly, she had marked on different occasions that I was on some kind of amphetamine, which is untrue.
Okay, you don't have those forms though with you.
I do, not with me.
This explanation from the witness is devastating to the defendant's entire argument, whether he realizes it or not. The supervision officer clearly lays out the difference between supervision levels and court-ordered conditions, dismantling the idea that these requirements were arbitrary or hidden. The mobile breath unit isn't optional. The urinalysis testing isn't negotiable. They exist because the court ordered level 3 DUI supervision. This moment exposes the real issue, not confusion but selective understanding. The defendant knew what level 3 meant when it suited him, but now claims ignorance when consequences arise. And when he finally says, "I understand," it rings hollow because the violations already happened. Understanding after the fact doesn't undo noncompliance. From the judge's perspective, this clears up any ambiguity and confirms enforcement was appropriate.
But
Okay,
I do have them.
okay. So I really don't think that that is an issue that is necessarily relevant to my determination as to whether or not you violated conditions of your bond. The fact that you've expressed to me today that in fact you were working part-time at some point, I don't know that that box, if it was inadvertent, which the court believes probably realistically was inadvertent, I don't know that the checking of that box really impacts anything from my perspective in terms of your compliance with the conditions of the bond. So
No.
if you don't have any other questions for Ms. Miller other than that, I'm not going to allow, I don't think I need to hear from her
Okay.
as a witness.
I do, I'd like to ask her if she knows what the bill and the bill for the act of concerning pre-trial release.
And she's not in a position to answer any questions regarding that. So her testimony wouldn't be relevant for the court as to that issue either, Mr. Ortega.
Well, I mean, I object to that because they are the
You
pre-trial.
can certainly object to it. And we're on the record here, but I don't think it's relevant to my determination. So other than that, was there any other question you wanted to ask Ms. Miller?
No, Your Honor.
And were there any other witnesses that you wanted to call?
I do have some, but they're not on my behalf that I think they should be here.
If there's a witness that's here today, sir,
John Bivens.
okay,
Your Honor.
and I'll do the same thing with Mr. Bevins. What do you want to call Mr. Bevins for?
Well, I want to ask him, with their policies and procedures, that they have to have some kind of policies and procedures.
And again, I think Ms. Tuttle's testified. She's the manager. So Mr. Bevins is just a case manager. So I don't think that his testimony, frankly, is going to be relevant or helpful to the court because I've heard from Ms. Tuttle. So was there anything else you wanted to ask Mr. Bevins?
I wanted to ask him about the instance when I came back from Arizona.
And Ms. Tuttle's testified about that, and I don't think I need any additional testimony regarding that. Anything else, sir?
I just want to state for the record that,
So what I'm asking you right now, Mr. Ortega, is to tell me whether or not there's any other questions or evidence that you wanted to get from Mr. Bevin. That's what I'm asking you.
no.